Okay. Good evening, good afternoon, and good morning to everyone on the call. It's really nice to hear to discuss data protection. I would like to start my presentation by telling us this quote. And the quote says, "Until we recognize that data is not numbers, we will keep treating it like numbers." I'll repeat that. Until we recognize that data is not numbers, we will keep treating it like numbers. What does that imply? It implies that on this discussion, come to the table knowing that data we are talking about here is you and I. We are talking about human beings, people who live, breathe, move like us. We are data subjects. And so with that in mind, we're going to dive into this discussion. And I hope we are able to make the best use of our time to appreciate the topic and how we come in as civil society organizations, recognizing that we are data controllers. Why are we data controllers? If we are data controllers, what does that mean to us? So the topic is civil society organizations as data controllers, our roles and our responsibilities. Basically, this is what we are going to be touching throughout the session. We'll be able to dive through it very quickly, at least within the next 30 minutes, we should be done. And then we'll go into the panel discussion to discuss further. So we'll be talking about the introduction, conditions that qualify us as civil society organizations, making us data controllers, our responsibilities, practical implementation, because this is where the issue is. Some lawyers on the call probably have gone through the Nigerian Data Protection Act, and yet you are still wondering, what exactly does this mean? How do I come in? Some people are asking, am I a data controller of major importance? Am I not? These are the confusions we want to address here, and we hope that by the end of the discussion, we'll be able to walk away understanding how we come in and what that implies to us in our day-to-day project implementations. The history. The first ever data protection law that came into existence was in 2018, and that was the GDPR. Thereafter, in 2019, under the NISDA, Nigeria came up with the Nigerian Data Protection Regulation. That was in 2019. However, it was relevant to us because Section 37 of the Constitution of 1999 had given us the groundwork to say we have a form of privacy rights. And then this regulation was being implemented under NISDA as a department. But as soon as the Tinubu government came into power, June 12, 2023, the regulation was then made an act. So we now have Nigerian Data Protection Act. However, Section 62 of the Act gave continuous life to the regulation. So all this while we're shuffling Regulation Act. But on the 20th of March this year, 2025, the General Application and Implementation Directive was passed. And the provision of that guide, which in Article 3, Sub 3, ended the life span of the regulation. It said by reason of the issuance of this directive, the Nigerian Data Protection Regulation shall be laid to rest. So from March 20th, the Nigerian Data Protection Regulation is no longer applicable. So fully, the Nigerian Data Protection Act is now what is obtainable. I must, however, specify that there's no significant difference between the regulation and the act. So it's not like we are moving from anything significant. So what is contained in this act? We have the goal, the main goal, like I said at the beginning, is to protect people's privacy. What is privacy? My name. You want to walk on the street and you want to call my name. Do I want everybody on my street to know my name? So the goal of this provision is to protect privacy beyond just the name. We'll go into the details. It's also intended to promote fair and safe use of data. You sit in your house and then you begin to get text messages. Pam, 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 and you're wondering, how does this concern me? Sometimes things that you are, people, places you have never been to. I still get mails from UK and I'm wondering who knows me in UK that is sending me mails and telling me, come and buy furniture, come and buy this. It's part of it. And then it's intended to create the office of the regulator. The commission got its power from this law. Then it's intended to encourage data awareness and good practices. Like the introduction said, I am a data protection officer because I work in a data protection compliance organization, because the law makes provision for data protection compliance organizations and gives us certain responsibilities, which is part of creating awareness, carrying out trainings, and that's why we are having this discussion. So the Act is intended to help us understand what it actually means to protect our data, not just for controllers and processors, but even for data subjects. Because sometimes it takes you and I as data subjects to be able to request for our rights, to have the controller wake up to their responsibility. For instance, there was a notification that was posted by Sir Babalola on LinkedIn, and he was calling out UNN. UNN had the entire data of their students on their website, including their date of birth, their home origin, so much data. And that notification called their attention to tell them this is wrong. So if you don't record, if a student in that school understood their right as a subject, they would have been the first to have made that cry out. So it's not just for us as controllers, but even for us as data subjects. And then it is intended to support Nigeria's digital growth. Remember, for instance, the General Data Protection Regulation of the EU, which is the European Union, says that unless you have these laws in place in your country, you will not have any dealings with citizens of their own country. So if you are a Nigerian entity doing your business in Nigeria, and then someone from the EU contacts you to say, oh, I would like you to do this business for me, and it requires the sharing of the data of any data subject of the EU, as long as your country does not have a law, the EU law says you can't deal with us. So if us now having an act in place, business owners from Nigeria can conveniently reach out and have businesses with such countries. And this is almost replicated in several other countries, because most of the other data protection laws we have are practically a replica of the GDPR. So that way, this act is helping us grow our digital economy, help us spread our services globally. And then it also helps us clarify responsibilities. Yes, everybody knows where they come in, what is expected of you, how is it expected to be done. And majorly, we are talking of the data controllers and the data processors. So this law clearly tells us their roles and their responsibilities. So what makes a civil society organization a data controller? A data controller is defined as anybody who processes personal data. Anybody who determines why we should collect data, what we are collecting, how we are collecting it, what are we going to do with it. I cite an example. You are hosting a program. You determine your attendance sheet. You insist that everyone who walks through the door has to fill it. You determine that they have to fill their name, they have to fill the name of their organizations, they have to fill their phone number, they have to fill their bank details because you want to refund their transport, they have to sign their signature. What else do they add on that attendance sheet? You know, all of these things are personal data. Sometimes people visit your office and then you have visitors register at the entrance. And then they have to fill their name, fill their house address, fill their phone number. Sometimes I think they ask for next of kin. So you who developed or designed that form and determine what the content of that form will be and what you have decided now you want to collect in paper. I'm sure some of us have probably visited the IOM. In IOM, they will tell you, scan this code, you scan it, and then it pops out a form, and then you have to now fill it. That is the means of collection. So if you opt that the means of collecting for yours is paper, that is the means of collection. And then you're also determining what you are collecting. And you also have your reason for collecting it. So all of those things determined by you. When I say you, please mind you, I'm talking of your organization, makes you the controller. So anybody who determines what will be collected, how it will be collected, why it will be collected, what we are going to do with it thereafter is the controller. Then if you have collected those data, let's say for instance, you are what's it called? A guarantor. Is it a guarantor or a guarantee? You are a project implementer. And then the founder says, at every session, you must collect this and this and that and submit to us. At that point, you are not the one who determines what will be collected, but you are the one collecting it. You are the one who will compile it. You are the one who will then send it to the founder. At that point, you do not now fall into the category of a controller. You are now a processor. Who is a processor? A processor is that person that now helps the controller process the data they have collected or process the data that they want to collect. Sometimes the processor may be the one collecting. However, he or she is not collecting for his own use. He's collecting on behalf of the controller. So if your own is just to collect and give to whoever asks you to collect it, who determines what they are collecting and why they are collecting, you are now a processor. However, the same rule that's applicable to the controller is applicable to the processor. It does not in any way reduce your responsibility. Vicarious liability and everything, in fact, the law says that the controller should tell the processor his responsibilities and ensure that they carry it out in the same way based on the agreement they have had with the data subject. So your responsibility does not in any way shift by reason of you being just a controller. But I want us to bear in mind that depending on the circumstance, we may either be controllers, stricto sensu, or processors, or controllers and processors. So what is this personal data I've been talking about? I'm sure I've mentioned a little of it here and there. Personal data is any information that can directly or indirectly identify a specific individual. Now, with the name. Once you call a person's name, let me see on the call, Philip. If there were two Philips on this call and I said, Philip, the next question someone will ask me is, which of the Philips? Then I may now say, the one that spells his name with double L, or the one that spells his name with one L. Sorry, my video screen is on this side. Let me balance it so I don't have to shift. So, by reason of one Philip spelling with a single L and another Philip spelling with double L, that changes who the Philip I'm addressing is. And then I could actually also have two Philips on the call. And then I say, Philip, the one whose profile picture is a black t-shirt. Automatically, the question of which Philip will not come up. We automatically will check the profile picture and then see the Philip who has a black t-shirt on his profile picture, and then he has been what? Identified. What does this imply? Beyond clearly defined official things like your name and your surname, by reason of certain characteristics being attached, we can tell who is being addressed. For instance, we are in a room and then I'm gossiping and I say, you see that woman that is always wearing black shirts when she comes to the meeting? That woman, she's very, very kind, but sometimes, do you know, without me mentioning the name of the woman in question, almost everyone who heard me speak may be able to identify that woman. So if, let's say, what I have said about her is not too good, it's not too kind, and she decides that she recognizes that she is the one I'm referring to, and she decides to attack me, I cannot now pretend and say, no, it's not you I'm talking to. The same is applicable in our daily business. So whatever helps to identify a person, it may not necessarily be their official information per se, but if it is personal and identifies, automatically we have a personally identifiable information. So beyond that, officially, we have full name. If you mention my name, Onyinyechi, unfortunately, I may not answer because I use more pseudonyms than I use my official name. So I may think maybe someone else in the room is being mentioned. But the moment you mention my name and mention my surname, except we are two in the room, which happens very often, especially amongst us Nigerians, automatically you are talking to me. Then what about identification numbers? NIN, no two people have one. BVN, no two people have one. Social security number in the US, no two people have one. So we have such unique identification numbers, even a passport number, not two people have one. So the moment you pick up an NIN and show who, it's just like when you go to the immigration to renew your passport. They may not call your name, they just call your passport number. You will stand up. You don't sit down and say, it's not me. By reason of that number, it becomes you. So whatever is being done with such a number, it is automatically being done to you. So these are the kind of data we are talking about. These are the kind of data we want to protect. Then we talk of location data. For instance, we say Donatus, who lives in Lagos. Even if there are two Donatus here, the one who lives in Lagos has been identified. So location data matters. People's address. Phone numbers are also individual. Not two people have the same phone numbers. Email addresses too are unique. Biometric data is further unique. Online identifiers, for instance, your social media handle. Your economic, religious, or cultural information is also key. For instance, you come to a meeting, and that meeting is meant to be secular. If someone stands up and says, all the Christians here stand up, whatever they want to do to those Christians changes the ballgame. If someone walks in and says, all the traditional religious worshippers stand up, it also has the same effect. The same for our IP addresses. We are all on this call right now. Every single person's device with which they have logged onto this call has a unique identifier. So all such data are the data we are referring to when we talk about what? Personally identifiable data. However, we have two classifications. We have the general one or ordinary one, and then we have the sensitive. In some cases, they are referred to as non-sensitive. Your name, for instance, anybody can know your name. On your street, people may know your name. People in your class may know your name. Your house address may also be common. People in your church may know it. Your email address, certain ID numbers, your photograph. But when it comes to the sensitive ones, for instance, your HIV status, that's your health status, your trade union membership, your political opinion, because today they may come and say they are killing all the Christians here. That changes the ballgame. So these are sensitive information. Tomorrow there could be a political clash, and then politicians of certain parties may be the target. So such information are way more sensitive. Even race and ethnic groups too are sensitive. So for the sensitive data, we expect that they will be given more protection and security. That doesn't, however, mean that the general one or the ordinary one or the non-sensitive should not still get the same protection, but extra security must be given to sensitive data. So for us in CSO, who are our data subjects? We have projects, we have project beneficiaries, we have our employees. Sometimes employees don't recognize their data subject because they're always the one taking data from other people. Your employees are usually your first data subjects. Your volunteers. So organizations will tell you we don't employ people, we only have volunteers. Those volunteers are your data subjects. Your project beneficiaries. Imagine, for instance, you are doing an OVC project. Such data is sensitive because people with such sensitive conditions, in fact, their name tells you, orphans, vulnerable. Their data is what? Sensitive. You don't just leave it lying around. Then we talk of community members, the community where you work. The people within that community are your data subjects. As long as you are collecting this information from them. This is different when, for instance, you come to a community and you just share rice and walk away. you didn't ask anybody for their name or anything, it's fine. But if you are going to be collecting data, which we often do in our projects because we want to defend and show working, automatically these people whose data we are collecting become our data subjects, participants in our programs or our research, or even our field officers who go in to collect a survey for us. So, and all other vulnerable population we support, for instance, organizations that work on maybe abused women, abused children, like the SACs, the Sexual Assault Referral Centers. You are dealing with high-class vulnerable people. So these are your data subjects. People should not know from you as the implementer or the data controller that, this person, this one has HIV. Oh, this one. No. That is the goal here. We don't want such data to be on the streets. And it takes you just one careless move. Let's say the book you use to collect that data is in a big note. Your program officer leaves it on a chair, and then your office driver picks it up and begins to read because he's idle, waiting for people he wants to drop off to come. And next thing he sees his neighbor's name. Hey, so this my neighbor has HIV. That information has gone out. So we must treat such places where we keep this data as secret, as valuable, as special. That is the whole goal here. So when we talk of data processing, what are we talking about? Whether you are collecting it with form, with app, whether you are recording it, whether you are organizing it, say, no, these ones are here, what we may call profiling, whether you are structuring it in any way, whether you are storing it, whether you are using it for other ways that we may classify as adaptation, or you are using it to implement projects, or you have to disclose it to your funders, or you are destroying it after use. Whatever you are doing, all of this fall under what? Processing. And automatically, whether you are doing it manually or with digital means, computer, phone, online apps, whatever it is, you are processing. And this is where the law comes in to say, if you are doing any of these and more, you are responsible. So we talked about the data controller being the one who determines the purpose and the means of data processing. I already explained that when I said the person who determines what is being collected, how will it be collected, what will it be used for, what will be collected, why are we collecting it, and then the means. Is it paper, is it app, is it online, are you scanning QR code, whatever it is, where are you going to store it? So you don't just come up and say, fill this form. No, first of all, you have to determine what are you collecting and why. We will dive into that a little more, but let's classify data controllers. Section 65 of the Act says that data controllers and processors of major importance. And then people are saying, what is major importance? What is minor importance? Unfortunately, there's no minor importance. We are all within the major importance. The only difference now is the classification that determines which class of major do you fall under. So we have the ultra high, we have the extra high, and then we have the ordinary high. These are determined by figures. Each figure determines where you fall under. Based on the guide directive that came out in March, we now have tier 1, tier A, tier B, and tier C. And these tiers determine the filing fee every category will pay. We have as high as 1 million for those who are processing over 500 data subjects under the ultra high, all the way up to 5,000 and above. We have processors of over 1,000 data subjects. These ones are falling within the extra high, and then over 200 fall within the ordinary high level. So if you are within the ultra high, depending on the tier you fall within, the highest cadre of filing fee is 1 million, we have that of 750, we have that of 500. But I don't want to go into these details because we are yet to confirm when this implementation will take its full course. But it was launched on March 20th. But what we need to know is that we have the ultra high, we have the extra high, we have the ordinary high. What is significant about the ordinary high? Ordinary high are not required to file every month. We'll soon discuss what filing means. All they need to do is come in and register each year to say we are processing personal data, we are processing personal data, but they don't need to file annual reports to the commission. However, not every class of organization is considered relevant within these provisions. There are some exemptions because Section 44(6) of the Act says that the commission can decide to exempt certain organizations where they consider that such requirements will be is it disproportionate. So certain organizations, based on the guide that just came out, excludes the following organization. The first is faith-based organization, where we have our churches, our mosque. I don't know whether I should add shrines there, but because we know that almost everybody is affiliated to one kind of faith-based organization or the other, asking such an organization to now process it, conduct filings and all of these things, we pose a challenge. However, this does not exclude them from still implementing the principles. No, the principles must still be upheld, but they don't need to file annually and all of that. And then community-based organizations. I know some CSOs are community-based organizations. So if your organization is community-based, you are not required to file. Then we have foreign embassies and high commissions. Then we have the judicial establishments or bodies carrying out adjudicatory functions. Then we have multi-government organizations. These categories of entities are excluded from the annual filings. Then what are responsibilities by reason of being organizations that collect personal data? Our responsibilities fall within what to do when processing data, what responsibilities do we have to data subjects, what administrative responsibilities do we have, and what responsibility do we have to carry out our data governance processes. The principles for processing are as follows. So whatever data you collect, you must abide by these principles. Lawfulness, fairness, and transparency. That is the first. So you must only process or collect data for lawful reasons. And you must do it fairly. And you must be transparent. What does that mean? Any data you want to collect, you are collecting it first for lawful reasons. You want to assume that that will be a general thing for all organizations on the call. What is fairness? You don't want to put something on that your attendance form that will give a wrong impression. For instance, let's say you are hosting a health program, or I remember vividly attending a grant training session. And during the session, the organizers just said, do we have our special groups in the room? If we do, wink at me. When you wink at them, nobody sees who is winking. So that is a fair way of doing was collecting that data. How about if that person had said, do we have our special groups in the room? Raise your hand. If they raise their hand, everyone else in the hall will see them. I don't want to begin to define what special groups means, but I hope everyone on the call gets the point. So it must be done fairly, and then it must be done transparently. For instance, you want to be clear on what you are collecting and why you are collecting it. So if you are collecting the data for the purpose of giving it to a third party, you should be able to say that. You shouldn't collect it and then later say, we don't need them to know. We just do what we want to do. Some people collect data and then they sell it off to people for advert purposes. I vividly remember we had a recent a call for application for trainings of young people, and as soon as people submitted the application, the next thing they start getting marketing mails. But that phone, never told anybody that we'll be selling your data to marketers. How about you go to a hotel and next thing you begin to get scam or phishing mails through this link if you want to get a Christmas gift? Because that hotel has someone within selling out data, which ought not to be. So at every point you are collecting data, you want to tell people what you are collecting their data for. And if you know that it will be used for marketing purposes, then you want to tell them clearly.
Okay,
and you want
about five more minutes.
Okay, and you want them to be able to understand what that means and how it applies to them. Then purpose limitation. If you are collecting data for project campaign, you cannot now turn around to use the same data for something else. Data minimization. If you don't need my mother's maiden name, why are you asking for it? If you want to do age bracket, why are you asking for date of birth? Storage limitation. You shouldn't hold the data forever. At the point where you are done using it, you must delete it. Then that data must be confidential. We shouldn't see our data of HIV positive patients on the streets, or next thing, the papers are sold off for selling akara. So duty of care and accountability, from time to time, these data subjects can come and say, that data you collected from me, are you still holding it? What are you doing with it? You should be able to answer. Lawful basis. You must have a reason for collecting that data. And it cannot be decided in between, halfway. You must decide it at the beginning. Is it for do you need their consent if you don't have a real reason, for instance, marketing? Is it for contracts? Is it for legal obligations? Is it in their best interest? Is it for public interest? Is it for legitimate interest? So whichever reason you are collecting it for, you must state so. Administrative duties. Every controller must appoint a data protection officer. You must have a way to manage consent. When you have collected consent from people, when they want to retrieve their consent, you must have a way of letting them do that. You must train your staff to know what to do with the data. They must understand their responsibility and keep it confidential. You must conduct impact assessment to know which process is risky. And when the process is risky and then you have done everything to avert the risk and you can't, you must revert to the commission. And then you must report annually. To report annually, you cannot report by yourself to the commission. You must go through a data protection compliance organization. And then you must report when there has been a breach. But if your data is not structured in a way that you understand when there's a breach, you have a problem. Then what are the rights of these data subjects? They must know what you are doing with their data. They must know what data you are collecting. Anytime they want to find out, they must come to you for access. You must let them see it. They can come and say, I got married, or my name has changed. You must let them correct it. They can also come and say, I don't want to be a part of you again. Whatever you are doing for me, I'm not interested. Delete my data. You must do it. They can also come and say, for now, don't process me again. They have a right. You will stop. They can also say, I'm no longer interested in whatever you are doing. I object to being processed. You must stop processing them. And then if they say, I know you are the one that has been giving me my antiretroviral drug, but I don't want you to do me again. Give me my file. I want to go to party A from B that you are. You have a right to give them such a file. And then in special cases, maybe someone who has been invited for job interview, you say the job interview will be digital and they can't speak well, they are scammers. They can tell you, I don't want to go through digital means. Don't process me through automated methods. They have a right to do so. When you are dealing with special children, not special children, special class of people like children, they cannot give consent. So you must interface with their parents. And this rule is applicable to other special groups we work with as NGOs. What do they need to understand? For instance, you are dealing with people who are hard of hearing or the deaf group. You don't give them anything as audios who are blind. You don't give them a consent form and tell them to sign if it's not in Braille. So their special needs must be factored in to make sure that they understand what it is you are doing with their data. Good governance process, privacy by design. At every point of taking off from your project, at the beginning, not later, you must factor in privacy. This data we are going to collect, how are we going to preserve it? What are we collecting it for? All of those things must be done at the beginning. And then you want to structure the data in a way that when someone comes to say, I want to change my name, you will not change it in one folder and it's wrong in the next folder. And from time to time, before you even start a project, you must check the risk. So that consent form you are giving them, you will tell them the risk they will face by reason of partaking in that process. And then they will now decide to make an informed decision. I don't care if my name is later seen on television. Like we give consent form to take people's picture. It is more than picture taking. Every other of our processes must be factored in. What are the practical implementation steps? We must develop policies. We must develop privacy notice. We must take care of all our documentation. We must have a consent form and a consent management process. We must have data inventory. What am I taking? Where are they? Where we talk about ROPA, report of processing activities, we must know what we are doing. It's not an uncertain process at all. It must be coordinated. And then we must have regular audits. Some people still have data of projects they implemented as far back as 1992. What do you need that data for? It is during those audits you have to determine, even your policy must determine your retention period. If your retention period says 5 years, after 5 years, those data must go out. Some people still keep data of dead people, and then when they want to have a program, they will invite dead people. We are invited to our programs. It's wrong. So our data must be current and correct at all times. What is the risk? From 2 million to 10 million, depending on your category, or 2% of your last year revenue. You see here, did not say profit. You now say, I don't make profit. It's revenue. So if you had grants of a certain number, 2% of that previous year goes in as fine if there's any breach. 2 million, depending on your classification, or as high as 10 million, whichever is higher. So if your 2% of your previous revenue is higher than 10 million, automatically that's what you get to pay. So this is what we need to keep away from us. And the fact that we are CSOs, non-profit, does not exempt us from this penalty. There's loss of credibility because everybody will get to hear that, oh, this organization, they were hacked or they were breached or their data is flying in the public. And the moment people now know that, oh, the data they sent to you is now in public, definitely you will lose your organization. So the communities you work with will be like, no, I don't want to have dealings with these people. And take it or leave it. Even funders will also be careful. And then beneficiaries can be harmed. Sometimes people from special communities' data flow from CSOs. And then they are targeted within their community because someone within heard or someone within leaked the information. And that is why training of your staff cannot be overemphasized. So, like we said at the beginning, data are humans like you and I. So we must respect their dignity. People who are working on, let's say, HIV projects, we still keep saying they are being respected. But the truth of the matter is that we still know that discrimination still exists. So such people's data should not be leaked. Your staff should not be talking. You come and say, you see that one? He comes to our office to take entry into the address. Oh, see this one? She was raped. No! Their dignity must be respected. We must prioritize their protection. Not everybody from the organization should have access to this data. We must also be transparent in dealing with beneficiaries. We want to tell them what it is we are doing. We want to tell them where their data will go. We want to build trust with these people. When we talk of confidentiality, we say when we are having counseling, we close the door. That is the same way we must close the door to their data. Beyond them walking in and then talking to us in private. All of the same way we guard what they have told us, in the same way we must guard even their name, the fact that we give them our services and all of those things. So even the way we structure our organization, who knows who talks to who, matters in this process. We must empower everyone to know their rights and be able to prioritize it. They shouldn't be in a position where they feel, what will I do now? Is that not the only thing it will mean for them to give me what I came for? So we must let these people know we respect you, we honor you, we protect you. Your interest is our priority. I think I have been able to touch every part of my slide, even though I had to rush at some point. I hope I was able to send the message home, but then we can continue discussion in the panel session. Thank you.